Court does call the case of People versus Julian Carey.
Here's what is appearing on behalf of people, Your Honor. Good afternoon, Your Honor.
All right. We're here on the motion, your motion for discovery, to compel discovery.
Yes, Your Honor, should I begin?
Go ahead.
Yes, Your Honor, I moved for discovery of potentially exculpatory material under MCR 6.201. I made that request in July. The prosecution had 21 days to comply and did not provide anything or any response until very recently. Last night I received his response to my motion. I filed a reply today, Your Honor. I'm not sure if you had a chance to.
I read everything, counsel, so.
I know I could. So if you read everything, then you know what I'm asking for. And I'm asking for discovery of communications between the alleged victim, who's a fellow by the name of Will Hathaway, outgoing Scioto Township supervisor, and communications between he and members of the prosecution team, which include officer.
How do I know these exist?
Sorry, how do you know? Well, I believe they exist. I know for a fact that there are emails after the discovery was produced to me between the key detective in this case, his name is Detective Parvis. He's the quote unquote computer expert in the case. And
Well, he's not quote unquote a computer expert. He's extremely skilled in what he does.
I'm sorry, I didn't
So,
mean
go
to
ahead.
confuse him, but I don't know what his title is. I was just saying computer expert. But he has been having communications with Will Hathaway, who's the complaining victim, and also with members of the IT department of Scioto Township. There have been emails, there's written communications between witnesses. And
How do you know that?
because I learned that from my client because Mr. Hathaway was talking about emailing with this gentleman. I believe they exist, and Detective Parvis also came to the township and met with Mr. Hathaway, trying to follow up on the information that we provided to the prosecutor, showing why this case is completely a non-case, that there was no crime that occurred in this case, not even a crime, let alone my client committing a crime. There wasn't a crime. An old email and an old meeting request were sent when my client clicked.
I've read that, counsel. I'm just trying to figure out how I know these things exist.
You don't, Your Honor. You don't know until you look. And when I asked the prosecutor for this information, he said, on information and belief, I don't think they exist. That is not the proper response from the prosecutor, Your Honor, and you know that. The prosecutor's response should be, I checked with the sheriff's department, or I looked at these materials, or they don't exist. All I got was,
Well, what information and belief? Why you may not like the response, but the response is his information would have had to come from somewhere. So you're talking what words he was using as opposed to anything else.
no, I don't think so. Respectfully.
Well, I do.
Okay, well, do you understand what I'm asking for?
Not really, because I don't know what documents you're saying exist that the prosecutor hasn't turned over.
Okay, I'm saying that there are emails for sure between Detective Parvis and Will Hathaway. He's a complaining victim, and I would ask for those emails to start. But I would ask for any written communications between any witnesses and the sheriff's department and the prosecutor's office.
Okay, so the only way you know that there are emails between Mr. Hathaway and Detective Parvis are because Mr. Hathaway said
If I have a
so?
moment, I can tell you exactly. Can you give me 1 second?
Sure.
So, Your Honor, the way we know that they exist is because Will Hathaway forwarded those emails that he was having with the detective to another member of Scioto Township, another employee. That's how I know.
So where's that employee?
You asked me for testimony from a witness?
I asked you a question.
Where is
the employee that says they got the emails?
Well, they're not at work now, it's past 4 o'clock and we didn't know we needed to have them here.
So this employee received, I'm presuming, on their personal email or on the Scioto Township email?
Scioto Township, Your Honor.
So my question becomes, why would your client, if they exist, not have access to those through their IT department?
Anything to me.
My client has not been able to get access to that. And I don't think she's requested
Well,
access.
counsel, do you have have you tried to get them?
Have I tried to get them? Me?
Yeah.
I've done a FOIA for communications at the township, but this is stuff that happened more recently when I did the FOIA. And it's, Your Honor, with all due respect, this is exactly what the prosecutor should be doing, is finding out, are there communications between my witnesses and my police officers that are.
No, with all due respect, what you will do is you will answer my question.
I'll answer your
Have
question.
you attempted to try to get them?
No. I mean, I did by filing this motion. How else am I going to get discovery, Your Honor? I guess I'm confused by your question. Have I attempted?
Shouldn't be confused by my question. Look, the prosecutor is not required to do what is really part of defense's job. Certainly, they must supply evidence that they have and comply with any reasonable request. But you come here to me today, and I don't know that these things that you're requesting, whether they exist or not. And the only way that you know that they exist is because somebody has said that these were sent to somebody at Scioto Township, and that it's between Detective Parvis, presumably, and Scioto Township. So my question is, on that end, why don't, if they exist, when did this happen? You're saying it's recent, but when?
I can get you a date. Within the last 2 weeks. But it's not just that, Judge.
If I may.
I think I'm still arguing.
No, I'm just trying to clear up the point here.
No. We don't do it that way here.
Thank you.
Just for a bit of context, Your Honor, if I may. Mr. Belota provided me with some information from some computer person Dave retained. And it had to do with a meeting invite that went out around the same time that this email went out. That information was emailed to me, and I don't know, because I'm not a computer expert, what it is that this information entails. I forwarded that information to Detective Parvis, and I've spoken with Detective Parvis. He's attempting to, I believe the term is the header information that is retained on the servers at Scioto Township. He's basically trying to vet that information, Your Honor. And so that has happened in the last few weeks, and perhaps in attempting to vet that information, Detective Parvis has been communicating with Scioto Township. I have no specific knowledge of that. I haven't been provided anything, but it wouldn't shock me that Detective Parvis is following up because I asked him to follow up. He told me that at some point he's going to provide a report to me. I don't have any sort of report, and I don't have any update for the court. I'm only saying that in as much as I am aware that Detective Parvis has been communicating with the IT department of Scioto Township over the last couple of weeks in response to information provided to me.
Okay, well, that's a big piece that's left out. So you provided something to the prosecutor's office.
Yes.
That your expert provided to you.
Yes.
And then from that, the prosecutor's office then sends that information to try to figure it out. So how do I get to there? And so that hasn't been completed yet.
I've not had an update or any reports. My understanding is the IT individual from Scioto Township, the primary person is out on some sort of leave. And the other information was that obviously with an election forthcoming, the current IT person has a lot going on. So there's a delay, I think, in getting that raw data to Detective Parvez so that he can, validate whether this is or is not true based on the defense expert.
So, I mean, is there anything in that that's not true?
No. And
So why am I here? If you gave them information and they're trying to unlock that information that you've given them, why am I here on a motion to compel that information where it's not been done yet?
because that's not what I'm not asking for a follow-up report. I'm asking for communications, Your Honor, and not just with Detective Parvez and the IT person, but most importantly between Will Hathaway and members of
Yeah, but doesn't that come from isn't that the subject matter of the meeting invite, or am I reading that wrong?
what is the subject? The meeting invite was for a meeting that happened 11 months or longer before. So it was an old meeting. That's why I say that this case was just essentially an IT issue. It had nothing to do with any individual action, anything. And that's why this case is in this courtroom before you on this matter, because there is no evidence. And that's why I wanted to spend some time talking about the case to show you that the principal witness is Will Hathaway. He is a political rival of my client. My client was running for the position that he now holds for the time being, supervisor of Scioto Township. And he is a long time political rival. So he's the one pushing this prosecution, Your Honor. He's the victim. He went to the sheriff and he's pushing this. So all of his communications with the prosecutor's office and with the sheriff, I believe I'm entitled to. And at the very least, I'm entitled to the court to make an in-camera determination as to whether there's anything exculpatory if they exist.
If they exist.
I know. This whole thing could be solved if the prosecutor had said in his response, I asked, and there aren't any. I asked the sheriff, and there aren't any emails. There aren't any texts. That's all he has to do, but he didn't say that. He said, on information and belief, I don't know about any. And that's just not enough. That's not enough.
So you wanting to use specific words?
Well, I mean, the Supreme Court said that he has a duty to investigate material within the possession of the police. And he's telling me that he doesn't think there is any, but he doesn't say that he even checked.
Okay, so let's presume this, counsel. You make the request. Mr. Childers goes to the police department. Police department says we don't have any. He then has to respond to you. He doesn't know that because he can't say they absolutely don't. He can only tell you what he's been told. So if that's all that he can say, he would have to say on information and belief based upon, which is really going to be based upon conversations he's having, I don't have anything.
Understood. And I've been on that side, and all I would say is, look, I asked, and they don't have it. Okay, and maybe he did ask. I'd love to hear him say that he asked. But what I've heard from him, and I met with the prosecutor, Your Honor, is I heard from him that Will Hathaway made a contradictory statement to him, telling the prosecutor that he himself did not write the email that was sent, the untimely email. He had said to other people that
I can't get into evidence on the case. You're asking me, I mean, you keep throwing this stuff out there. I don't know if that's the evidence or it's not the evidence. I'm here on your motion, which is quite frankly improper in the way that you drafted this motion.
How so?
But because you lay out all of these things that, and quite frankly, counsel, made certain accusations against people in some conspiratorial sense that turned out not to be true. For example, you specifically stated that Patricia Reiser authorized the complaint. I went to the complaint. I looked at the complaint. She did not. And then that was before I got the response from the people because I didn't know for sure.
I didn't say that. I said that she worked there and that was her job, and that's factually accurate. And
then you misled the court because you made it seem, as the one's reading it, as though she's the one that's authorizing it. Don't tell me, counsel, what my impression of it was.
Okay.
And I think you intentionally tried to mislead me. I'm going to let you know that.
I did not.
Because that didn't happen.
That's good. I'm glad it didn't. It shouldn't happen. It shouldn't happen, but it also shouldn't happen.
You know what? You better sit down because you're going to learn real quick how to address this court. I don't play that way. I'm going to take a recess. You check yourself and then I'll come back. Court's in recess. Counsel, you've indicated emails between Hathaway and Parvis. What else are you looking for?
Thank you, Your Honor. And let me just apologize to the court. I know you took a recess, and I want to say I'm sorry. I did not mean to disrespect the court in any way. I apologize if my arguments came across that way. I would say it's probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I very much apologize. Other things besides that, Your Honor, communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for, communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then I'll.
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during our.
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings. The defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings, inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney that the only way we would do anything on the case is if she passed the police polygraph, because as this court well knows, that's standard procedure. That offer still stands, and Ms. Carey wants to avail herself to a police polygraph. Not only would I welcome that, I think that a result on that could be highly dispositive in a case like this. It's my understanding that she's not willing to do that. That's her right. That's fine. As far as my communication with respect to emails, the statement that I was responding to that I would not turn over would be internal emails in our office among the attorneys, because clearly that's work product and that would not be turned over. But in fact, in that conversation, what I told defense counsel was, candidly, there are no emails. I've never emailed with Mr. Hathaway. If I had, it wouldn't necessarily be discoverable. It could easily be work product, but those emails don't exist. I've never emailed with him. I did communicate with Chris Reiser in our office. Obviously, I wouldn't communicate with John Reiser, and to insinuate others is frankly, when I read the pleading, I had a thought to communicate with the bar regarding the ethics of the pleadings and the communications in this case. I am not aware of any email correspondence between Detective Parvez and Will Hathaway, and I'm not in possession of. Obviously, if there's a report that Detective Parvez produces, and that report insinuates or includes those emails, those will be turned over. If the report reads as if there was email correspondence between Detective Parvez and Mr. Hathaway, I will ask Detective Parvez, please attach those emails in your report, and I will tender them. The court is well aware of the work product that I do and the ethics that I hold and how the fact that in this case, the allegations that this is some grand conspiracy is
The court proceeding
Counsel,
opens with a
you've
high-stakes
indicated
legal
emails between
confrontation in the
Hathaway
matter of
and
People
Parvis.
versus Julian,
What
where
else are you
defense
looking
counsel
for?
submits a formal motion to compel
Thank you, Your Honor.
discovery.
And
The
let me
defense
just apologize
contends
to the
that the
court. I know you
prosecution
took a
failed to
recess, and I
disclose
want to say I'm sorry. I
potentially
did not mean to
exculpatory
disrespect the
material
court in any
within
way.
the
I
mandated time
apologize if
period
my
after the
arguments came
request
across that
was
way.
initially
I would
filed
say
in
it's
July.
probably due to
Counsel
my
asserts that the prosecution was given
extreme belief that
21 days to
compliance is
comply,
absolutely
but
I
did not
apologize for my
respond
zealousness.
until the evening prior to the
Making you
hearing.
feel that I was being
The attorney
disrespectful.
further
I
argues
apologize.
that certain communications
Other things
likely
besides
exist
that, Your
between
Honor,
the alleged victim,
between
Will
Will
Hathaway,
Hathaway
identified as a
himself
political
and,
opponent of the defendant,
members
and
of the
members of the
prosecution
investigative team,
including
including a
Parvis
detective
and
assigned to the case. The defense maintains
Deputy
that such
Phillips,
communications could
the
contain
officer in
information
charge of the
supporting the
case.
defendant's innocence
So,
or,
that's what I'm asking
at
for.
minimum,
Communications.
undermine the
And I don't need to say
prosecution's
any more.
theory
I'll
of the
rely on my
case.
brief.
However,
Well,
the court
no,
promptly
I do
questions the
have a question.
defense on a key issue:
How do I
how
know
counsel can
these
confirm the
exist?
existence of these communications.
Uh,
The attorney
you don't.
concedes that this
You don't.
belief is
I only know what
primarily
I've heard and
based
what
on
I've reported
statements
to the
from
court.
third parties,
And what I was
including
asking
the
is for
defendant
the
and
prosecutor just
individuals
to check.
within the
Maybe I
township
misread
who
his
reportedly
response. Maybe he was
observed or
saying
received forward
information belief
emails.
means he checked.
This
I just want to know
acknowledgement
if he looked
raises
and if there's
immediate
nothing,
concern
then
for
Did
the
you
court,
ask?
which repeatedly
I asked for them,
challenges
and
the
he said he wouldn't
reliance on
provide them,
assumption
so
rather than
they weren't
verified
they weren't
evidence.
discoverable.
The judge emphasizes
During our-
that a
Mr.
motion
Childers?
to compel discovery cannot
The
rest on
problem, this is now
speculation
like the
or
third time in
hearsay
this hearing,
and
as
must
well
be
as
grounded
multiple
in a
instances
factual
in pleadings.
basis demonstrating that
The
specific
defense
evidence
is
exists and is being withheld. The
misrepresenting
defense
statements
attempts to
that I've
support its
made, to the
position by
point where I don't
stating
feel
that the
comfortable
alleged
speaking with the
victim
attorney absent
previously
being on
forwarded
record or
emails
in
to
writing.
another township
We've had phone
employee,
conversations
implying the
and turns
existence
and
of
somehow the
communication
subject of those
between
phone
witnesses
conversations
and
shows up in the
investigators.
pleadings.
However,
Inconsistent
when
with
questioned
what was
as to why
actually
the
said.
defense did
There
not
was a
seek those
statement in the
emails
pleadings
directly
that,
from the township's
that
IT
the fact that the
department or
defendant
through
passes
formal
private
legal
polygraph,
methods
I
such
should
as
act upon
subpoenas
it, even
or
though I
document
specifically
requests.
told the defense
Counsel
attorney
fails to
that
provide
the
a
only way we would
satisfactory
do anything
answer.
on the case
The
is
court
she passed the
reiterates that
police
the
polygraph
prosecution
because as
is
the
only
court
required to produce
knows,
evidence that
that's standard
actually
procedure.
exists
That
and is
offer
within
still
its
stands in this
custody
period
or
once we avail
control,
ourselves to a
not to
police
conduct
polygraph.
expansive
Not
searches
only
on
would I
behalf of the
welcome that,
defense.
I think that
At
a
this
result on that
stage,
should be
the
highly
prosecutor
dispositive
clarifies
in a
that the
case like
defense
this.
recently
It's
submitted
my
technical
understanding that
data
she's not
through a
willing to do that.
computer
That's her
expert.
right. I don't,
In
that's
response,
fine.
investigators are
As far
currently
as
examining
my
server logs
communication with
and
respect
reviewing
to
digital
emails,
metadata to determine
the
whether any
statement
relevant
that I was
communications are
responding
present.
to,
The
that I
prosecutor
would not
further
turn over
informs the
the
court that this
internal
review
emails in
remains
our office
ongoing
among
and
the
no
attorneys,
formal
because
report
clearly
has
that's
yet been
work product, and that
finalized.
would not be
He assures the
but
court
in
that
fact,
if
in
any
that
findings
conversation,
reference
what I
emails
told
or other relevant
defense counsel
materials,
was,
such evidence will be
candidly, there
disclosed
are
to the
no
defense
emails.
in
I've never
accordance with
emailed
legal
with Mr.
obligations.
Hathaway. If I
With
had,
this
it wouldn't necessarily
clarification,
be
the court
discoverable. It could
reassesses
easily
the
be work
situation.
product. But those
Rather than
emails don't
indicating
exist. I've never
intentional
emailed with
concealment,
him.
it
I did
appears that the defense's
advisor in
newly
our
submitted
office.
data
Obviously, I
initiated an
wouldn't
active
other than to
investigation that has not
insinuate
yet
others
concluded.
is frankly.
The judge questions the timing of the
When I
defense's
read the pleading, I
motion,
had a
suggesting
thought
it would have been more
with the
appropriate to
bar
await the completion of the
regarding the
analysis
ethics of
before
the
alleging
pleadings and the
non-disclosure by the
communications in this
prosecution.
case.
As proceedings continue,
I
the
am
court
not
also
aware of
raises
any email
concerns regarding the
correspondence
tone and
between
wording used in the
Detective
defense motion,
Parvez
which
and
implies
Will
potential
Hathaway, and I'm not
misconduct or
in
bias
possession
by
of.
prosecutors and
Obviously, there's a
investigators.
report that
The
Detective
judge
Parvez
cautions that making
produces,
serious
and that
allegations
report
without substantiated
insinuates or
evidence is
includes those
improper
emails. Those
and
will
may
be turned
harm
over.
counsel's
If the
credibility
report
before the
reads as
court.
if there was email
While recognizing the
correspondence
duty
between
to
Detective
advocate
Parvez and Mr.
zealously,
Hathaway,
the judge
I will ask
underscores that
Detective
claims of
Parvez,
conspiracy
please
or
attach those emails in
wrongdoing
your
must be
report, and I
supported
will
by
tender them.
factual proof.
The court is well aware of the
Accordingly,
work
this
product
phase
that
of the
I do,
hearing
the ethics
shifts
that I hold,
focus away from
and
the
how
underlying
in
charges and toward the legal principles governing
the fact that in
discovery,
this case,
ethical
the
conduct,
allegations that
and
this
the
is some grand
obligations of
conspiracy.
attorneys when presenting
Counsel,
claims in
you've
court. By the
indicated
conclusion
emails
of this
between
segment,
Hathaway
courtroom
and
tension has
Parvis.
escalated,
What else are
with the
you
judge
looking for?
indicating that the defense's position appears
Thank you,
to
Your Honor.
rely more on
And let me just
assumption than
apologize
on
to the court.
established
I know you
facts.
took a